So, very good morning, all of you. Respected chief guest of today's program, Mr. Dipanjan Bhattacharya, Special Secretary, West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal. Today's resource persons, Dr. Mohua Home Choudhury, Scientist C and Nodal Officer of Patent and Information Center, Government of West Bengal. Another resource person of today's program, Srimati Papia Shaha, Paromita Shaha, excuse me, Government of West Bengal, Patent and Information Center. Our beloved Principal Madam, Dr. Madhumanjari Mondol, respected Vice Principal Sir, Dr. Supratim Das, Bursar and Joint Director of Research and Development Cell, Dr. Upendranath Nandi, IQAC Coordinator and also Joint Director of Research and Development Cell, Dr. Shamrat Bhattacharya, Senator Secretary Madam, Dr. Bedisa Sinha, Teachers Council Secretary Madam, Dr. Indrani Kaur, Convener of this program, Dr. Partho Haldar, my dear fellow colleagues of various departments, last but not the least, my dear students, ladies and gentlemen. Today is one of the important day for us. On behalf of Scottish Church College Internal Quality Assurance Cell, Research and Development Cell, and Institutions Innovative Council, I would like to welcome you all in this inauguration program of IPR Cell and inter-department presentations of innovative ideas for IPR. And the whole program is sponsored by West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal. To begin with, I would like to request Mr. Pinaki Mondol, Department of BBA, to offer opening prayer. Sir.
Let us pray. Thank you, Heavenly Father, for this wonderful opportunity, a wonderful day that you have added in our lives. In this morning, we consider ourselves blessed and privileged that you have handpicked us and given us this opportunity to take part in this inauguration program of IPR Cell. Please be present amongst all our deliberations. Bless our chief guest, all the other dignitaries, and the officials and dignitaries from our college. Especially bless those resource people and as well as our dear students. May this inauguration marks a new beginning of new glory and new success in the heart of Scottish Church College. And as you have said, those who seek me, they will find me. So in this fine morning, we seek your presence and we seek your blessing. Be with us, guide us, and provide us with all your blessings and your holy presence. We ask this prayer and we submit all our plans and all our deliberations into thy holy feet. In your name we pray. Amen.
Thank you, Mr. Mondol. Now I'd like to request all dignitaries to come up on the dais and take their seats. Principal Madam, Vice Principal Sir, our chief guest, our resource persons, and our Bursar Sir, please come up on the dais. We will begin this program with the lighting of lamp. So I would like to request all the dignitaries, please come in front for the lighting of the lamp, and they will be assisted by Dr. Shatabdi Ghosh, Department of Botany, Scottish Church College. Please. Thank you. Please be seated. This is an important initiative of Scottish Church College to nurture the innovative ideas which may come from the students and faculty members of the college, and to sensitize intellectual property right through this program. And the whole program is sponsored by West Bengal State Council of Science and Technology. And today we have two sessions. In first session we have two lectures. After that we have display of innovative ideas. And who knows, from those innovative ideas we may get few patents in your future. So at the beginning I would like to request our principal madam, Dr. Madhu Manjari Mondol, to give welcome address to the audience. Ma'am, please.
Good morning, everyone. Chief guest of today's program, Mr. Dipanjan Bhattacharya, Special Secretary, Government of West Bengal. Resource persons, Dr. Mohua Homchoudhury, Scientist C, Government of West Bengal, and Srimati Paramita Saha, Scientist B, Government of West Bengal. Dr. Supratim Dash, our Vice Principal, Dr. Shamrat Bhattacharya, IQAC Coordinator, Joint Director of Research and Development Cell, and President of Institution Innovation Council. Dr. Rupendranath Nandi, Bursar and Joint Director of Research and Development Cell, Dr. Bidisha Sinha, Senator Secretary, Dr. Indrani Kaur, Teachers Council Secretary, Dr. Partho Haldar, Nodal Person of IPR Cell of Scottish Church College, all my respected faculty members who are present today in this inaugural session of the opening of IPR Cell in our college, and my dear students who are eagerly waiting for participating in research and innovation activities of the college. On behalf of Scottish Church College family, I welcome you all. We are indebted immensely to West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal, for sponsoring the event of inauguration of IPR Cell and interdepartmental presentations on innovative ideas for intellectual property rights. This is indeed a very auspicious moment when we have gathered together to start our journey towards more innovations and startups in this institution. Though our researchers are working hard to establish their findings through publications, but patenting the products have not been done except for one or two cases. Our alumnus, Mr. Dipanjan Bhattacharya, first stated this idea of IPR in a career orientation program organized by the Department of Botany last year. After that, the initiatives were taken by the college to establish a proper research and development cell following the guidelines of UGC. IPR committee was part of that cell, but through Dipanjan, we came to know that DSTBT, Government of West Bengal, had a scheme to promote the opening of IPR Cell in different institutions, and then we applied. Now a grant of 50,000 rupees has been sanctioned for this purpose, and we are really thankful to the department for granting such amount to start this activity in our college. In the meantime, we also have received an amount of approximately 1 crore from DST Feast to develop an infrastructure for research and development in our postgraduate departments, that is, in the Department of Botany and Chemistry. We are very hopeful that our faculty members and our students will take our college to a greater height in the field of research and development. In this regard, our another former student, his name is Mr. Gautam Devnath, who actually resides in USA, also has agreed to help us to promote innovative works of our students by rewarding them a prize money of near about 1 lakh per year for the best innovative project from the college. Today, our students will display their projects in that direction only. We also are planning to establish one incubation center for promoting such activities. Many former students are with the college, and we hope that the developmental activities will continue and it will remain in our institution. I'm thankful to all of you who have come forward to initiate and develop the environment of research and innovations in the college. May God grace us with His blessings to go forward in this direction. Thank you again to DSTBT of Government of West Bengal. Thank you.
Thank you, ma'am, for your encouraging words. Now we are going to felicitate our guests. First of all, I would like to request our principal madam to felicitate our chief guest, Mr. Dipanjan Bhattacharya, and she will be assisted by Ms. Camelia Nundi, Department of Botany, Scottish Church College. Thank you, ma'am. Then I would like to request our Vice Principal Sir, Dr. Supratim Das, to felicitate our resource person, Dr. Mohua Hom Chaudhuri, Scientist C. Oh, sorry. Extremely sorry, ma'am. Now, I would like to request our Vice Principal Sir to felicitate Dr. Mohua Hom Chaudhuri. He will be assisted by Dr. Shatabdi Ghosh, Department of Botany, Scottish Church College. Thank you, sir. Thank you, ma'am. I would like to request now our Bursar sir, Dr. Upendranath Nundi, to felicitate our resource person, Srimati Paromita Saha. He will be assisted by Dr. Somali Mukherjee, Department of Chemistry, Scottish Church College. Thank you, sir. Thank you, ma'am. Now, I would like to request our Vice Principal, sir, Dr. Supratim Das, to say a few words about this program. Sir, please.
A very good morning, our esteemed guests and dignitaries on stage, my dear faculty members and other staff members present here, dear students and ladies and gentlemen. We have a lot of programs almost every day in the college on different occasions. But today's program, to my mind, is substantially different because the college is going to inaugurate the IPR Cell, a cell dedicated to intellectual property right protection. I was just asking before coming here, Mr. Dipanjan Bhattacharya, my own questions about intellectual property rights scope and activities. To my mind, most of us, particularly I mean my own community, most of us from my own community, we are quite unaware of the exact application and function of intellectual property rights. We have very vague ideas. If this is one, the second one is that, as I am from social science, as far as intellectual property rights are concerned, there are divergences, strong differences of approach and application from discipline to discipline. Intellectual property rights, as they may apply to science disciplines, will not be same in application and in their jurisdiction to or from the rights when they will be applied to humanities, the disciplines of humanities, liberal arts. The problems and perspectives will be different. The very definitions, to my mind, will be different. So first of all, we have to understand the complicities and the divergences, number one, and number two, how to address the issues. So this is so good that we are going to have an intellectual property rights cell in the college, but the cell must be very active because this is something very new and there may be umpty number of expectations. Because what is intellectual property right? What is the expanse? And how do the rights really work as some codes of law, international law? Because just I would finish with 2 or 3 questions or my queries. Number one, to my mind, with the rise of law and economics movement, the focus of, economic analysis of intellectual property has drastically shifted to more concrete and manageable issues. Among the issues, some of the most important ones are, number one, the length of protection for intellectual property. Number two, the rules that allow considerable copying of intellectual property without permission of the originator. Number three, the rules governing derivative works. And number four, derivative works, not the original works. And number four, alternative methods of providing incentives for the creation of intellectual property. So, I think there will be many more questions, but the sale, our sale, has to be familiar with the laws, with the application, with the realities, and with the problems. So they can go, they can move so many miles in future. So I wish all the very best, and today we all will be very much enlightened because we have esteemed speakers, they are the experts. Just as a very ignorant person, I was trying to raise some of the issues. Thank you.
Thank you so much, sir, for your valuable speech. And I think we may get answers of all this through this program, which is going to be organized jointly by our IQAC and Institutions Innovative Council and also Research and Development Cell of Scottish Church College. Now I would like to request our chief guest, Mr. Dipanjan Bhattacharya, Special Secretary, West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal, to say a few words about this program. Sir, please.
Acha, good morning to all of you. যদিও 12টা বাজতে যাচ্ছে, but still 11:50, so technically we can say good morning. First, I will be, I'm grateful and very thankful to Scottish Church College, especially Principal Ma'am, Vice Principal Sir, and other faculty and the students for inviting me to this occasion. It so happened that I also was a student of this college. So it's always a privilege to come to this, your alma mater, once in a while, and do some tangible things for the college. Incidentally, যেটা IPR নিয়ে এতক্ষণ কথা হলো, I will be switching to Bangla এবং ইংরেজি. I think that will be more acceptable to the students, most of them. So, intellectual property right নিয়ে যে কথাটা হলো, কারোর কোনো এক কথায় যদি আমি জিজ্ঞেস করি যে intellectual property রাইটটা কি, তো there is a particular thing which is called the intellectual property right. Intellectual property means intangible creations of human intellect, এক কথায়। অর্থাৎ আচ্ছা, ছোটবেলায় সবাই শুনেছে যে জগদীশচন্দ্র বসু প্রথম ওই বেতার আবিষ্কার করেছিলেন এবং তিনি তার পেটেন্ট নেননি। তো মার্কনি গট দ্য পেটেন্ট, যদিও এটা নিয়ে অনেক গল্প টল্প আছে, একটু বড় হয়ে বড় বইতে পড়ে অনেক কিছু জানা যায়, যেটা ব্যাপারটা হয়তো পুরোটা সেই রকম ছিল না। বাট দ্য পয়েন্ট ইজ, ইট ওয়াজ অ্যান ইনভেনশন ইনভেন্টেড বাই Sir J.C. Bose. It was the creation of his intellect. So it's an intellectual, it was an intellectual property. Something which is not there, created by human intellect, but it may not have any physical dimension. It's an idea, it's a formula, it's something which is creation of human intellect, which was not there, which is called an intellectual property. This may be an invention. Invention is what? Something which was not there. It was created. But this may again be an innovation. What is an innovation? Innovation is something is already there. I am twisting, turning, tinkering with the things and making it and using it in a novel manner, which was not used before. So it's an invention. These two things, invention and innovation, actually comes into the gamut of intellectual property, which we will be discussing in this case. Achha, I know very little of the subject matter as such. I have some vague ideas, but the two scientists who are there of the government of West Bengal, Dr. Mohua and Paramita, they are the one of the expert minds in this matter in the whole state, and one of the better, especially Mohua, is one of the better persons to talk about this in the whole country. We have a very good intellectual property rights cell in our department. They do basically works on patents, on copyrights, on trademarks. Whatever you may see all around, you may see the maximum works are done by them to facilitate things. They also do very good work in the case of the GIs, the geographical indications. Nowadays in the কাগজে তোমরা সবসময় দেখে থাকবে ওয়েস্ট বেঙ্গল এটা জিআই পেলো, ওটা জিআই পেলো, যেগুলো লাস্ট কাগজে এসছে, যেরকম ধরো সবাই জানে রসগোল্লা থেকে শুরু করে মসলিন কদিন আগে এসছে, টাঙ্গাইল শাড়ি এসছে, বালুচরি শাড়ি এসছে, সুন্দরবন হানি এসছে. These are got the GIs. About 27 GIs they have done. This all the handiwork of this team, especially Mohua and Paramita. So at present we have another 30 odd GIs underway. So these things are there. Now why this thing is important? Because a lot of them you will be doing innovative works, and the faculties are always doing innovative works. It is very important to know the rights which we can do, otherwise we may not get any tangible return from their works. This is why we require these things. In the innovation parlance, there is a worldwide innovation council and all these things. It is based in the Geneva. Geneva na Vienna? Geneva. Geneva. So it is in the Geneva, and they have this particular scaling of the innovation level of a country. India incidentally have at present, I think, third largest pool of technical people. That means doctors, engineers, PhD holders, research scholars. It has got, I think, second largest number of publication in the world. Right now, the last figure which has come out to us, we had to keep ourselves somewhat up to date in these regards. But on the innovation scale, we were at around 80 positions in 5 years ago. But in last 2 years, the government of India has given immense pressure on the innovation things. Beforehand, patenting of a single product, এখানে কারোর পেটেন্ট আছে কিনা আমি জানি না, it used to take 5 to 6 years, তাই তো? It is, now it has come down to the 1 year. That is because of pressure from the highest level of the government or something like that. So Indian Innovation Council is also doing good work. We are also trying to catch up with them. So it has come down drastically. Now India is ranked around 30th in the innovation scaling, but it has a very long way to go. Because we are studying, we are doing work, we are doing research, but we are not innovating. Simply not innovating. এখানে অমিতাভদা আছে. এখন we come from the same background. That is a botany. মধুদি আছে. So we get lots of project proposals for the research scholar projects where the PI will be one of the faculties. I think this college also has Nilanjan. Ache to naki? Acha, Nilanjan knows. We also provide funding to this college also, PG college, as they have some research works. But the point is, out of that, we are getting some publication, is fine, but absolutely no innovation. The sorry state of affair, especially in the state of West Bengal, is like this in higher education, that till date in last 7-8 years, the Department of Science and Technology has provided, run the project in the science and technology, not in humanities, of course. That is beyond our purview. More than nearly 600 projects. Out of that, we got, I think, 20 odd patentable public things which can be patentable. And not to say anything about the market acceptability. So we need to change our approach. We absolutely need to change our approach. We need to go into the more innovative works, more detailed work, more studies which can have a great impact. On whatever, and which can in the long run, on the short run also, can generate some revenue out of that. So this is one of the things. It is not something that cannot be done. For example, কোভিড হয়েছিল কিছুদিন আগে, আমরা সবাই বিভিন্ন জায়গায় বিভিন্ন কাজ করেছি। আমি তখন অন্য ডিপার্টমেন্টে ছিলাম, প্রচুর কাজ করতে হয়েছিল। The primary vaccine which ultimately saved the world was developed by Oxford University in association with some other institutions. For example, Queen Elizabeth Hospital under Birmingham University, something like that. The entire the patent of that lies with that consortium. And it is generating enough revenue to run a substantial part of any of those universities for next decade or two. So this can be done. It was not a very, it was a great innovation. It was no invention. It was innovated with the existing techniques and ideas. Same thing was done, replicated in India by Bharat Biotech. The two most effective COVID vaccines are one developed by one of the private companies of India. That is the Bharat Biotech. Covishield and here Covaxin. So it can be done. We have necessary intellectual prowess, but we are not doing it. Basically, IPR এর মধ্যে অনেক কটা জিনিস পড়ে। প্রথমত পেটেন্টিং একটা বললাম, জিআই একটা বললাম, ট্রেডমার্ক, কপিরাইট। এখানে ওই সুপ্রতিম স্যারের সঙ্গে কথা হচ্ছিল যে একটা পাবলিকেশন কেউ করছে, তারপর সেটা পাবলিক ডোমেনে চলে যাচ্ছে। এনিবডি ক্যান প্লেগিয়ারাইজ ফ্রম দ্যাট। সব সময় তো আর ওটা প্রজেক্টের জন্য যাচ্ছে না। ইট ইজ নট গোয়িং ইনটু প্রজেক্ট। এখন প্রজেক্টের জন্য দিলে আমরা প্লেগিয়ারিজম চেক ফেক করি, সফটওয়্যার আছে, এগুলো করা হয়। কিন্তু কেউ একটা কারোর লেখা থেকে হুবহু তুলে দিচ্ছে, তুলে দিয়ে তার নামে করে দিচ্ছে, তার ফলে সে কিছু সুবিধা পাচ্ছে, অসুবিধা পাচ্ছে। তো ইফ you take the copyright of your publication, the original publication, you have a right over that, so you can ask for remedy, you can ask for the share of money and whatever, and this is equally acceptable to both the humanities and all these things. Then the trademark. I understand the college has a logo. The trademark kora ache. Then anybody can put on that logo in the name of, say, Scottish Church College, SCC. It has a brand name. Scottish Church College still had a brand name. I hope it will remain so. But কেউ নাম দিয়ে দিল, ধরো ঝড়াফোজাক, Shawarafudi Christian College or something, SCC, and produce the same logo. You can't do a thing until and have taken the copyright. So this is something. For example, যে নাইকের যে ছাপওয়ালা জুতো ফুটপাতে বিক্রি করে, তৈরি করে, কিন্তু ও ফুটপাতেই বিক্রি করতে পারবে, কোনো ব্র্যান্ডেড স্টোরে যেতে পারবে না, as because Nike mark is, with the copyright is there, it is protected internationally, it can do great harm to any country if they say that we are producing these things. So it has an effect. Then again, যখন এখানে কাজ হচ্ছে ইনোভেশনের কথা একটা বললাম, সেকেন্ড এখন যেটা বললাম মেনলি যারা হায়ার এডুকেশনে পিজিতে যাবে, ইত্যাদিতে যাবে এবং যারা আমাদের এখানে আছে তাদের জন্য, ইট হ্যাজ গট এ গ্রেট কেরিয়ার অপশন। হিয়ার দ্য স্টুডেন্টস মে বি, সাম অফ দ্য স্টুডেন্টস মে বি interested. Some people are here, mostly I think the science students, there may be some humanities students also. But I can assure you, if you have a biotech background or a physics background or a chemistry background and you do a course under, I think MacOut does a course here. So MacOut in collaboration with us, they have a course on IPR. That to PG course ache na? PG diploma. There's a PG diploma course. If somebody along with this, whatever you have done or doing, you take that diploma, so এটা বোধহয় ডিস্টেন্ট এডুকেশনেও করা যায়, অনলাইনেও তো হয়, অনলাইনেই কোর্স আছে। So you can have a career option because now all the big companies, especially in the pharmaceuticals, chemicals and everywhere, they require the people who understands patenting, they can file patent, they can process patenting, they can see the patentability of any product. So there is a career option. It is there. For the faculties, we have our own faculty development program as this IPR cell is already functional from today. So I will ask the college to send the nominations. So we will give them a short course so that they can permeate the basic ideas to the students. That we will do. That is entirely on our cost. There is nothing will be there. So we will do that. We are also trying to develop some other classes. So let's see. But it has got a great career option. After doing PG diploma, one can specialize in IPR things, and in the job market, there is sufficient work available. This vista of Indian research and ecosystem, and of course in the private market ecosystem, it is opening up. So it has a great future. So people who are especially good students in their own manner, they can get an additional knowledge. When I saw the GST certificate course is going on in this college, I was very excited because GST is something which is also has a great potential. IPR also has got a good potential in our country, because our country must innovate, otherwise it will not happen. The whole research and development যেভাবে আগে হয়ে এসেছে সেটা না আমি এখন বলছি না, আমি খুব বাজে বাজে কথা বলি ওই নিয়ে, তো সেটা আমি এখানে বলছি না। তো সেই পুরো সিস্টেমটা চেঞ্জ হয়েছে। ইউ হ্যাভ টু টেক দ্য প্রবলেম ফ্রম দ্য মার্কেট, ফ্রম দ্য সোসাইটি, দেন ইউ হ্যাভ টু ডু সামথিং হুইচ ক্যান অ্যামেলিওরেট দ্য সোসাইটি, হুইচ ইজ ক্যান বি ট্রান্সলেবল। ব্লু স্কাই রিসার্চ খুব ভালো জিনিস, কিন্তু সেটা সবসময় মানে আকাশে পৌঁছায় না, এই মাথার কাছে ঘোরাফেরা করে। তো দিস আর দ্য থিংস, অ্যান্ড আই হোপ দ্যাট these words may be of some value to the people, but it is again a great honor for me to come back to my alma mater, and Scottish Church College, as always, have a very special place in my heart. Thank you all.
Thank you, sir. Thank you so much for your valuable suggestions and encouraging words. I think students should keep this in their minds, and for future reference they will use that. Now we are going to our first technical session. Our first technical lecture will be delivered by Dr. Mohua Hom Choudhury, Scientist C and Nodal Officer of Patent Information Center, Government of West Bengal. Her topic of discussions will be role of IPR in research and development. So I would like to request ma'am to deliver her lecture, as we are eagerly waiting for this.
Good afternoon, one and all present here. Honorable Special Secretary Sir, Honorable Principal Ma'am, Honorable Vice Principal Sir, and other faculty members, students, thank you for inviting me in this inaugural session. So I take this opportunity to take the initiatives to set up IPR Cell in your esteemed institution. Before initiating my core of the discussion, as our Honorable Special Secretary Sir mentioned that the purpose of what is the purpose of IPR Cell? So the objective of IPR Cell is to create awareness among all the faculty, students and others, and to have some initiatives to take up from this Scottish Church College to protect your intellectual properties. These intellectual properties may be patentable, may be copyrightable, may be industrial design, may be of trademark. So the purpose of this IPR Cell, we have already given some target also. So I am not mentioning the target. However, let's start. Let's click what to go. Actually, we have to reach our destination. That is why, as many students are here, so I have changed my topic, unlocking the entrepreneurial adventure, finding the perfect path to start your own business, role of IPR in technology commercialization and research and development. As because in NEP 2020, creativity, invention, multidisciplinary research has been given thrust. So with all this multidisciplinary research, creativity, invention, what to do next? Next, we need to commercialize. If we do not commercialize, then we will do the reinventing the wheel. The same research will work. If we transfer our technology, then some amount of research fund will come and it will revolve and new modifications will come, again IPR. So the technology modification, technology regime will be up in our India as well as in for our state also. As our Honorable Special Secretary Sir mentioned, India is now in 40th position in Global Innovation Index. However, West Bengal is 11th position in Invention Index or filing of patents. Before COVID, our position was 9th. However, after COVID, we are down in the position. So we need to cope up with this situation. This is the high time to cope up the situation and to be in this line. So that is why this workshop is very much pertinent with the scenario, global scenario, as well as Indian perspective and in our state perspective. So from morning to night, every one of us, we are facing different problems. Why? Even those women who are handling kitchen, we are facing the problem of sink junk. It is a regular problem with some tea leaves and other different things. Then how the problem is solved? There is some enzymatic solution in the market. So if we throw it, it may be cleared. However, if some students have some innovative idea and have some mechanical device to clear the junk, then it may be a new modification also. Once that garden cleaning was problem and it was only done by hand. And when the lawnmower is in the market, then the problem was solved. So what we have to do? We have to focus our problem and identify the problem. Then we may start the invention process. So what is that? Identify the problem, collect information, think creatively, then we have to do experiment, then review. Whether we are in the same position or we have modified something. However, we always suggest before initiating your research, you need to review where you stand. What is your location? And your nearby location is the same research is doing. So if the same research is going on in different institutes, so there is no modification. So that is why location searching is very important, that where I am standing now. Now I am in Scottish Church College, and whether the nearby college, they are doing the same thing. Then we have to think of to change our research area. That is the thing with the patentability assessment. So we are in the startup ecosystem where our department is there, who is funding organization. This Scottish Church College is there. Different universities is there. But there is very few linkages among us. So that is why we do not know what is the patent, what is copyright, what is different aspect of intellectual properties. Now I'm giving some facts and figures from 2017. If we look into startup trends, that for patent trends, we are in 11th position. But if we look into the startup trends, 2017 global trends, Bangalore is 20th position, and top 25 in 2018, Delhi is in 21st position. In COVID situation, Bangalore is also in 26th position, but nowhere West Bengal is there. We are lagging behind with the time. So this is the high time to cope up with the situation. So we need to have some idea. Then from this idea, some technology need to be developed. But before developing, we need to scan our technology, whether we are doing the same thing or we have modified something. If we do not modify it, we are doing the same research. We need to modify and we have to find out the technology gap. If we are not finding out the technology gap, then we are doing the same thing. That is the feasibility and market study. Then you can also modify your technology modification. After this technology modification, if you are not in a position to protect your technology, then that technology will be protected by your colleague, your friends. Then you have to buy your technology from your friends. So this is the time to take up the situation and file your patent, encourage your creativity, and click and have actually in line with the situation. So basically this is 3 to 5 year roadmap. How? You have to have some ideation, then design thinking, then engineering, then the validation. So for technology transfer, this is the 6P, which was very important. First is proper research, proper paperwork, proper pricing, publicity, partnership, and people's acceptance. If your research is not accepted by people, then it is not nowadays the research as per national education policy. Innovation, creativity is given thrust nowadays, and the total concept has changed. But I have engaged another P, protection. That is why it is now 7P. If you complete this 7P, then the research has some meaning. Whatever our Honorable Special Secretary communicated, if we have not actually comply with this situation nowadays, project is not also giving from our department also. We are doing regularly patentability analysis whether this research is unique or not. If this research is not unique, funding is not given nowadays. So this is very alarming, and we have to take the initiatives for innovative research. Now I am giving different glimpses of invention. Now first is the social invention. Every invention has societal impact. For elderly people, everything is problem. When they can't open the jar, if some students develop some jar opening system, it solves the problem. And solving of this problem, it is the invention. Then comes financial invention. Every invention has the aspect of financial part. Like here, Ellie Whitney invented the cotton gin to produce cotton faster. When some technology is simple, when some technology modified the prior art, when some technology is speeder, then the technology solves the problem of the state of art or prior art. And when it solves the problem, it becomes inventive. And if it is not inventive, then it is not fulfilling the criteria of invention and also the patentability. That is why we need to think of this. Then come, what is the difference between invention and innovation? Suppose if you have some idea, it is the invention. And you work out that, and it is novel idea, it is inventive, it has some industrial applicability, then it is invention. However, when it is innovation, when it is ready to market. So if you have developed some technology, it is not ready to market. When it is ready to market product type, then it is innovation. So this is the difference of invention and innovation. Next come intellectual property. Intellectual property is the creation of mind. It may be literary, it may be artistic, it may be symbol, it may be invention. Just in the inaugural session we are discussing about copyright. It's a very important right. We will discuss about this, and if we miss the opportunity, the next time it will not come to us and it will be taken away, and we will be in the legal infringement and legal things are coming. So that is why it is very important. As it is mentioned, the intellectual property is creation of mind. Every mind in a nanoseconds, we are in a thinking mind. When we write it, the idea is in our brain, it is not protectable. So when it is a tangible product, tangible device, then it is in the protectable ideas. Like when it is a device, when it is a process, then it is patent. When it is a writing form, then it is a copyright, then other rights I am discussing. So now I am giving a very simple definition of patent. Patent is a grant for an invention by the government to the inventor. Patent is a grant for an invention. Mind it, not for a discovery. Then what is discovery? Suppose we have discovered some plant. It is not patentable. Suppose we have discovered some new properties of some metal. It is not patentable. Suppose we have characterized some existing system. It is not patentable. Suppose we have done some study-based activities. It is not patentable. Suppose we have done some theoretical model. It is not patentable. If we have the publication of our documents, that is not patentable. That is copyrightable. So like software in India, software is also not patentable. So there is the thing in patent system, it is written what is not patentable. So you have to find out which is patentable. So patent is a grant for an invention. Then what is invention? If it is novel, if it is inventive. Inventive means, suppose you have 5 documents you have read before initiating your research. Document 1 is D1, document 2 is D2, then D3, D4, D5. Suppose no one have the idea what about you are doing, then it is novel. But combining the idea of D1, D2, D3, D4, D5, you have done some research which is unique. But as it is a combination of the 5 documents, then it is not inventive. So these 2 important criteria is most actually important things for patentability. It should be novel, it should be inventive. Otherwise, it will not be granted patent. Then comes industrial applicability. So, by the government to the inventor. Here lies the second point, to the inventor. Suppose you are doing the work in this college. Then you are the inventor. However, this institute will be the applicant. Then patent is granted to applicant. Applicant will market it. And inventor will also get some royalty sharing. That is why we are discussing about the IP policy. So every college, every institute should have some clear-cut IP policy. That when patent, copyright, and copyright is the name of the author, but if the patent is the name of this institute, then why individual inventor, students will be encouraged? They will be encouraged as it is said the royalty will be shared among the institute and the students and faculties. That IP policy may be actually issued or noticed. Otherwise, it will be very difficult to have more and more research. Then in exchange for full disclosure of the invention. So you have to disclose details about the process and product composition, whatever you have developed. But we always suggest, don't disclose exact optimum temperature, optimum pressure, optimum configuration, because it is your trade secret. Always discuss the ranges of temperature, ranges of pressure, ranges of specification. Otherwise, your trade secret will be taken by someone else. So that is why we always suggest this. To deter others to exploit the invention for commercial success, you have to have something that in your mind that this invention to be working. That means the technology to be transferred for a limited period within the geographical boundaries of the nation. For a limited period means if you file patent today, it will be effective for 20 years from today. So that is for a limited period. Afterwards, it is off patent. Every public can use it. So within this free period, after granting, you can sell it, you can market it, you can transfer it, you can license it. So you can do anything within this 20 years after granting. However, we always suggest after filing patent, you start technology transfer process. Otherwise, if granting takes more time, though nowadays the time frame has reduced, within the geographical boundaries of the nation. So each and every point has some meaning. Within the geographical boundaries of the nation means if you file patent in India, it will be effective in India. It will not be effective in USPTO. So if you file here, you can sell here, you can market here, you can provide licensing to anyone to here only, not USPTO. However, the point is there, you become inventor all over the world. That means for that invention, you become inventor all over the world. So novelty purpose, no one can cut down. So I'm giving the simple example of invention. A lock. Lock may be patentable. Every one of us, we have seen lock. So why? How? It can be patentable. Yes. A door lock. Recently, last year, I was in NIT Jamshedpur. They were discussing, they have devised some lock where one key is used to open the lock, another key is used to close the lock. That means the design, functional design inside is completely different, and patent is granted for this. And also, there is chemical composition or biochemical composition. If there is any new biochemical composition used as a lubricant, that may be patentable. There any improvement on it. And in India, software is not patentable. So, till date there is no digital lock. But suppose I have forgotten to close my door. So if there is any software hardware combination so that I can operate from here and close my door in my residence, then it is a new invention. So digital lock, a combination of software and hardware, it may be patentable. So anything which makes our life easy and simple, cost effective, and technology upgradation is there, then it is patentable. So very many simple thing may be patentable. So these are the three important criteria. Already I have mentioned novelty, inventiveness, and usefulness. What is novelty? An invention will be novel if it does not form the state of art. Inventiveness, invention must come through some inventive steps. I have already discussed. Suppose you have done literature review, even you have to do patent literature review. Otherwise, you missed lots of documents. So that is why when you initiate your research, before that, patentability analysis is important. Nowadays, all this research from different parts of the state coming to our Patent Information Center, we are checking novelty, then the grant is given to that institute from our DST. So novelty checking before initiating your research, even BIRAC research, they always mention, please put up novelty search documents. Then they are giving BIRAC fund, that big grant and other grants for that novelty search. Even we have done many BIRAC research searching procedure. So it is very important. Then usefulness. Suppose someone developed some COVID-like germ as a weapon, biogerm, then it is not patentable as it is not industrially used. So these three important criteria need to be actually stick to mind to have patent. So what should patent office look for? Patent office look for to file patent immediately if your idea is inventive. If you miss the bus, suppose you have already published the documents, then by recent amendments, you get 1.5 year grace period. Suppose you have already published your documents. 1.5 year grace period, nowadays you are getting from patent office. 1 year without fees. For 6 months, you have to provide fees for each month. So that is why if any inventive idea within you, just do the patentability analysis and ready for filing patent immediately. Then our Honorable Special Secretary already mentions that Professor Jagadish Chandra Bose is not interested to file the patent. When I joined 25 years back, I am in this field for last 25 years. So when I joined in this department, I got the opportunity to find out this letter written to Rabindranath Tagore. Professor Bose is writing that telegraph company is in front of me, but I am not interested to file the patent. My invention is for all. Afterwards, my papers was vanished. Then the Marconi got the patent. We know the history. So if we are not interested to file the patent, the same thing will be repeated. And when some technology is protected by someone else, then we have to buy the technology from that country, and automatically the cost of that technology is increased. But we have the capability, but we are not interested to take the invention. Even I was in Kashipur gun factory for IPR workshop. They are telling, ma'am, we are not doing any new things here. We are only arranging and rearranging. So that means all is coming from China. But we can manufacture here. But we are not taking care of that. We are also, for everything, we are depending on other country. And that is the thing, we need to develop our own power, own technology. And that is why invention, the importance of invention lies there. So, the next important story is that Swami Vivekananda requested Bhagini Nivedita to go to Professor Acharya Jagadish Chandra Bose. And Sister Nivedita requested Jagadish Chandra Bose, as Swamiji directed, to file the patent in USPTO. And this is the next patent that was missed, but this patent was filed in USPTO. This is detector for electrical disturbances patent. And this is the first Indian patent in USPTO. It was 1904. So Swamiji has already given the roadmap. So what to do next? Nothing to actually share afterwards. So everyone need to take up the research in such a way that it is patentable, it is inventive, it is new. Then I'm giving just some glimpses of telephone that you can see. This is the Graham-Bell model. These are the models, different models. Why these different models are there? Because all the models solves the problems of the previous one. And that is why it is inventive. And lastly, this model, was protected in 1975, cellular phone. But when we received our first cellular phone in India, 1990. So we are 15 years backbencher. So in the digital world, we need not to be backbencher now. We need to take up immediately the situations, and we need to file patents immediately if I have some innovative ideas. Suppose here I am giving very simple technology, very simple. You can see this where all of us, and previously also many, our grandparents, everyone sees where. But someone thought that where, if it is developed in such a way, it becomes James clip. And it is inventive. And what is the usefulness of this James clip? Till date, it is so useful, we cannot actually throw it. Then comes needle. For this needle, we are doing so much of fashion. So it is only the hole, creation of hole in the simple wire. The wire is some thick wire and some hole. And different developments of needle is there, and that is why there is a huge development in the fashion industry. So this is invention. Then comes simple heater. What is the problem of the simple heater? The problem of simple heater is that if it touches the bucket, there may be chances of electrification. So someone developed this crisscross arrangement and 4 floating ball so that it can easily float in the bucket. So it solves the problem. So it is the invention. So you need to identify the technology gap in any technology. So that is why patentability analysis, before initiating your research, if you do the patentability analysis, you will get lots of patented documents. From that document, actually starting those documents, you can find out the technology gap and then work on it, and it will be patentable. Otherwise, the same thing is reinventing the wheel is going on. Then you can see waste can in the mountaineering area, Himalayan area, lots of waste can is there. Someone developed some designer chair out of this waste can, and the process is inventive, so that is why it is patentable. Now I am giving another example of patentable idea, bionic eye. Through this eye, some blind can see, and it is the invention of USPTO. And what about the royalty you can see? Yes, because it solves the problem. And that is the thing. So we have to identify the problem, focus on the problem, not to repeat the problem. The last 2-3 years, we have set up 31 IPR cell, and I am going through all the corners of the state and seeing most of the research is the repetitive research. So that is why this is the high time to take inventive research, innovative research. Otherwise, we will lose many things. Now students, you are there. Can you identify patented product on this desk? Any patented product on this desk? Anyone? Anyone? Just give any answer. Yes, mobile. Everything. Actually, everything is patentable when it solves the problem of previous one. Then it becomes patentable. Everything in this room may be patentable. that means instrument, device, apparatus, may be patentable if it solves the problem. Even nowadays, lightning is not done by remote. If suppose madam is very busy, principal madam there, and nowadays is the digital system is there from there. So if you improve upon it, then it may be again patentable. And recently we have some project, research and development project, where some paneling was done from jute composite for the acoustics of auditorium. And the patent was filed. The sir was telling some 20 patents from research and development outcome. One of these patents is that jute composite based paneling for acoustics of auditorium. So nowadays those chemical and not is biodegradable, but jute composite is biodegradable. So when it is not in use, you can throw it. So it is not actually hamper our environment. So research should be like this. Hey, everything is patentable. Now, you can use the patent for your own use. You can license it, you can franchise it, you can merchandise, and all this thing is possible through your patent. Now the question is, can idea be copyrighted? Can idea be copyrighted? Possible? No. Actually, idea is in our mind. Idea is in our mind. It cannot be copyrighted. So when we write it, when we express it, suppose my presentation today, if Scottish Church College wants to record it and wants to sell it, then whose copyright is associated with it? So one as copyright is selling, because Scottish Church College is selling it. If they are used for their research purpose, if they use for their study purpose, then the copyright issue will not come, because research and study purpose is fair use. But if Scottish Church College is marketing it, then whose copyright is associated with this program? As a resource person, myself, Paramita, and as during the inauguration program, all the faculties, those who are in the dais, their copyright was associated with it. So as it is published by Scottish Church College, with them the royalty need to be shared among all these copyright players. So copyright is a bundle of right. It is not a single right. It is a bundle of right. When the author writes, it is published by someone else. So publisher's right is also there. So here you can see the right of the performers, right of the producer, rights of the music director, rights in title song, rights of the broadcaster. However, copyright is a moral right. It cannot be violated in any time. So anyone, just Sir was asking, and we are discussing about that some PhD work of Sir, it was copied by someone else and they are projecting in their website. It is unethical and it should be stopped, as because they are copying and they are giving their name. So we need to stop this. And for the books, rights of author, rights of the publisher, rights of a person publishing the books. So these are the bundle of rights. For software, as already mentioned, in India, software is not patentable. Then what is patentable? Suppose, I think you have seen dishwasher, washing machine, that is patentable. Because there is in the back end, some software is there, and it is a combination of software, hardware. So whenever any system is a combination of software and hardware, it becomes patentable. So to make any idea patentable, you need to search the technology, what is available in the market. Then you need to have some brain work, and then have some idea and work on it and get some new invention. So then come adaptation of various work. That is poems, songs, sound recording, PhD work, anything. So if I study previous literature and I am writing some review publications, then we need to change the language, definitely. If we copying the language, then it is the plagiarism. So if we actually mention the author's name, then it is not plagiarized. Like when Rabindranath Tagore's work in 2001, it was going to extinguish, we were in Vishwa Bharati. And today's Chief Justice of Supreme Court, Pratibha madam was with us, with DST team. She was there and she suggested Vishwabharati that you start a new work in different language, the Rabindranath Tagore's work in different language. Then a new copyright will start and it will roll on. And no one can copy the things and mutilate the songs and other things. So it was suggested during that time. Though it was not done, I have not seen. But however, if someone mutilated the song of Rabindranath Tagore, it is the actually violation of moral right. It should not be done. It should not be done for anything. Sad work has been taken up without his permission, so it is unethical. It should be actually, it should be protected. Then that is why we need to protect our copyright registration. It is not so costly, only 500 rupees for official fees. So it is not costly item. So you can protect your copyright whenever it is necessary. And then copyright exists lifetime of the author plus 60 years. So, and even if after your death, if anyone just translate the language, then a new copyright will start in his or her name. Next important intellectual property is industrial design. It is not design patent. In Facebook, you may see, I have some design patent. I have 70 design patent. It is not patent. It is design. Then what is design? Industrial design is design of any article, design of even the shape of this pointer. This is this type of shape, but in the market different types of pointer is available. So this outside design of any article is industrial design. Even some PCR machine, if some portable PCR machine has been developed by someone, then that portable design may be registered under industrial design registration. So feature of shape, configuration, pattern, ornament, composition of lines, colored. Here you can see in Indian Patent Office, this has been protected. This simple design, Bata shoe, they have also protected their design. And here, suppose you protect this cup design, and your institute, there is some research is going on, biodegradable plastic. And through this biodegradable plastic, if you create some cup, the design is also inventive and the process of biodegradable plastic is also new. Then you can protect biodegradable plastic process by patent, and the design of that cup or bottle or anything, whatever you are creating in your mind, that is design registration. So no functionality can be protected through design registration. Functionality means that how through this process biodegradable plastic is prepared. So this process cannot be design registered. Design registration is possible only the outside, like outside design of this Pradip. So you can also protect this. These are the different articles you can protect through industrial design registration. Here I want to mention that agricultural method is not patentable. Horticultural method is not patentable. Medicinal diagnostic method is not patentable. However, the outside design of horticulture instrument, agriculture instrument, laparoscopic instrument, it can be protected through industrial design registration. And the instrument also can be protected through patent. However, diagnostic method is not patentable. During the inaugural session, and also we are discussing that Professor Shanki from PG, he has some research on some body parts. It is actually used as a surgical purpose. This surgical method is not patentable. If there is new medicine, biomedicine, then process of this biomedicine, preparing this biomedicine, composition of that biomedicine, that can be protected. Instrument can be protected. However, the diagnostic method, agricultural method, how the plant is actually arranged, that is not patentable. So I'm just giving the example of infringement of design. You can see the pattern of these two design is almost same. Outside pattern. If the design is same, then it serve the purpose of novelty criteria and it will not be registered. Now, the next important intellectual property is trademark. Suppose you have a company of biodegradable plastic. You are processing biodegradable plastic. The process is unique. Then you can protect this process through patent. And the characterization, you can write and you can protect it through copyright. Characterization part. And also the design of the bottle, outside design, you can protect through industrial design registration. And who knows you? The company name? No one knows the company name. So you need to have some name. Otherwise, no one knows that you are doing the work. So naming of your company or of your product is trademark. It is the indication of your company or of your product, of your service. Like during the inaugural session, it was discussed about the logo of this college. It is Scottish Church College logo. It is service mark, as this college is providing the service. As it is established almost 200 years ago, so everyone knows this logo. Nowadays, if they copy, it is the violation of work. But whenever, suppose some research school has been established under this college, and that research school, Innovation Council, they have some logo. You have devised some logo. So you need to register it. Otherwise, it may be copied. As it is a 200 years logo, it is known to everyone nowadays. But even you can also protect. Protection is always better. However, no one cannot, no one can violate this logo and they cannot use it. So here is another important different issues. Like we have seen Boroline, Colgate, Collegiate. In the same line it is written, Lakme, like me. You cannot actually recognize this is like Lakme and like me. In the same font, same coloring they are actually using. So this is the violation of trademark. And another important thing I want to mention here, trademark should not be descriptive. Suppose your company is a leather company. You are telling the company name, real leather. It is not possible as it describes your product. Like the HP, Apple. What is the relation with the computer software and computer with the Apple? Is there any relation? So logo should be designed in such a way there is no relation with your product. So no one know that you are actually selling this product. So you have to have popular in the market with that logo. Then a small kid will identify, oh, this is Coca-Cola, this is soft drink. So no one need to explain this Coca-Cola actually sells soft drink. So this is the system. For this trademark that should be like this, everyone can know, oh, Colgate. Even a small kid knows that it is just toothpaste. So that's it. That is the thing. So you cannot even file trademark immediately. You can popular in the market, afterwards you can also file. However, during that time, some company also, nowadays it is happening every time, some company may encroach with the same logo also. So that is why we always suggest first search your trademark and file it first. Even I am giving you small story of, before going to geographical indication, I am giving another story of trademark. Like a small company, MSME, here in that southern Goria area, they have set up, the company name was Double Decker Lane. They are selling some sandwich, innovative sandwich, like it's very good product, Double Decker Lane. The trademark was very innovative and it was granted by Trademark Office, Trademark Office, Government of India. It was accepted, advertised, everything has been done. Afterwards, Coca-Cola company has actually infringed and give notice of opposition to him that you cannot use this product. What is the relation of Coca-Cola and double decker lens? Actually, they have copied the font of Coca-Cola in writing double decker lens, because that font was also protected through copyright. And he was a very small company. He has not big money to fight with them. That font is there, but the language and the meaning of that will not actually violate the situation. But he can't fight because the font is protected. So mind it, font you cannot also be copied before filing trademark. So there lies the invention. So before filing anything, you need to check with the expert. So next, the story of Basmati. Basmati is our rice variety of India. And what happened to Basmati? Rice Tech company, they have taken our Basmati and protected in USPTO. And these are the claims which they have protected. And after 3 years, in 1997, Basmati was protected in USPTO. After 3 years, CSIR scientists challenged it, and it was revoked. This claim was revoked for 15, 16, 17. And the name was changed Basmati rice lines. And it was actually given Basmati rice. During that time, there was no protection system of our plant varieties, our biodiversities, our plants, and traditional products. Even turmeric. Turmeric was patented by our Indian scientist in USPTO. Our Indian scientist protected turmeric in USPTO. This is the patent, you can see. Here it is written, own healing property, which is known for ages. But Shumon K. Das Kohli from India, they have patented it. Afterwards, this Magjauna Latvia, here it was written, that own healing property was written, and it was placed in the court, and then it was revoked. And for also Basmati, and there was some written documents where it was written, Basmati was used in Badsha Bhog. And that literature helped to revoke that Basmati patent. So here lies the multidisciplinary research in NEP 2020. That's we are fortunate to working in this IPR area. We got the opportunity to work with the history and the traditional technology and the recent technology. So when afterwards the new system of geographical indications come in 1999, it is the protection of traditional technology system. It is our grandfather's invention, because our grandfathers do not know how to protect that invention. So we have protected like Rashogolla. I think you have seen that movie Rashogolla. Here there was that, yes, in that movie, that wife, Nobin Chandra Das, she requested to file the patent. But Nobin Chandra Das was not actually interested to file the patent. And afterwards, everyone just copying the technology, and they start to actually produce these Rashogolla. Now Rashogolla become community right. So geographical indication is for community right. A great community is preparing, and there is a separate preparation process of Odisha Rasgulla, because they have also objected. Afterwards, we have produced that they are using semolina. But we are not using. We are pure chana, and our process is also different. And that is why texture is also different. So that is why we have done the characterization, texture analysis, molecular level analysis. So protect our traditional technology, to protect our grandfather's invention, we are doing research. So here lies the multidisciplinary research. So in this way, we have to work. Then we can implement NEP 2020. So otherwise, it is very difficult. And for to implement this NEP, I would like to request that before entering the students, you need to have some workshop-like program. That what is your choice? How to develop the invention, that creativity. In that workshop, you can find out and you can also suggest them. You can take this combination of things. Like music therapy is used to actually recover many critical disease. So someone who is interested in medical biotechnology or medicine, they also take music as a subject because they need to know which music can click very easily and very easily cure the system. So that is why it is the beauty of this NEP system, and we need to actually cover with this thing. So here lies different geographical, I'm not going all these details. Here we have protected 27 GI of our state, where muslin is there, Sundarban honey is there, Tangail is there, Gorod, Korial, Baluchori Shari, mango, and different product is there. But till date, it is not exported. So students have enough opportunity to work with our traditional technology, export the market, and there is many problems associated with this traditional technology. You know, what is the problem of Rasgulla? Rasgulla, to increase the shelf life. Only canning technology, through this canning, we can actually market it. But canning is a very costly technology. If there is any modified atmosphere storage technology or other technology, through this technology we may actually carry. Any questions, sir? Yes, we have protected 27 registered GI and many more products will come, and these are the logo. So in one product, everything is possible. Patent, design, trademark, copyright, trade secret and GI. I am telling, I think some one of you have some smartwatch, but we have to charge every time. So if any researcher have nano solar cell, then if it incorporated in this and it is easily taken solar charging, then it is new smartwatch, then it is patentable. Then comes design, outside external feature. If some hexagonal shape or zigzag fashion shape, then it will be new design. Then trademark, it is Titan. If you create Titan, then it is the similar trademark. So you have to be innovative in creating trademark. Then comes copyright, engineering drawing of that particular watch. That is under copyright. Trade secret, that the exact composition you should not disclose. And Coca-Cola company know the formulations, 2 persons knows the formulation, and they do not fly in the same flight. If there is any accident, that all composition will die. So in that way they protect their trade secret, and GI is Swiss watch. In this way we can protect all this. And now in the patent system, if woman applicant is there, if institute is there, then you get chance to expedite granting of system. Expedite granting, and within 1 year also patent is granted nowadays. So what you have to do? Write down the invention. Check whether your invention is patentable or not. We are there as a nodal agency. We are doing patentability analysis, so you can send to us. Afterwards, you develop the capability in the college. Then you can also do the search in-house and you can send to us. We will do the patentability analysis. Afterwards, novelty search, if it is okay, if your invention is new, then go for filing patent with the expert and then file provisional specification. If you are in the initial stage and you see that it has a great potential, but all the experiment has not been done, then file provisional specification, not complete. If you are ready, then file complete. But if you are not ready, then file provisional specification. Then you get 1 year time to complete specification. Publication of the application within 1 month if you provide the fees. Afterwards, you have to give the request for examination fees. The patent will examine and a first examination report will come. And afterwards, patentable, if you actually reply of this first examination report was given, if it is satisfactory, sometimes patent was granted. And sometimes there is some hearing, and after the hearing, the patent is granted. So in a nutshell, it is the process. There is many things in between that. So Paramita will discuss something after that, and it actually requires skilled, lots of time to know all this process. It is very difficult to know all these things in 1 or 2 lectures. That is why we are organizing faculty development program and PG diploma course that already Sir has communicated. It's an online course and it is in the night. So you have to complete all your work, and in the night you can do intellectual property rights course to know about this. I'm not doing all these things, and I am giving one glimpses of patent landscaping or patentability analysis before your research. Here I am giving glimpses of renewable energy area. As because if you do that patentability analysis before your research, you can find out your location. That means whether other institute is working in this area, you can find out. Here, patent analysis in renewable energy area, we have found China is the top in this tally. Number of patents you can see, I am not repeating. The General Electric is the highest patent owner, and these are the area where most of the research is doing. So, you click the research and you can get the details of the documents. And clicking this patent, you can get which is doing, which is the main research already been done. And you can find out the technology gap and start your research on this area. Then it will be patentable. Even for neem research, we have found the neem Holdi. Holdi was patented in USPTO. Afterwards, we have done in 2017 some work. We have found 344 application in India on Holdi research. 309 was published, 37 was granted, only one from our West Bengal, Jadavpur University. So you can see that Amity University was the top in that tally. And there was a unique research in Holdi, biofuel from Holdi. And it was done from Nagpur-based some automobile engineering college. They are doing this research and they have patented it. And for neem research also, India is the second position, and India tops the tally when it was granted. So here is another fact. You can see Coca-Cola can. Their inventor licensed the system. This Coca-Cola can was licensed at 1/10 of a penny per can. During the period of validity of the patent, the inventor obtained 1,48,000 UK pounds a day on royalties. So, if the invention is like this, so what is the earning you can see? So, we have the facilities for startups, researchers, academicians, unique facilities, idea clinic. We are organizing idea clinic in our department. So any idea, any research, you can share there because it is a government forum. So there is no harm to share there. We will guide how to move to have patent and technology transfer also. So this is mentoring support for prototype development and connected to incubation facilities. So we are also technology hunt program. We have some technology program. So here I have a few slides. I'm just ending here. Here is a innovative ideas. Here is that you can see that it is a cap. It is a small nano composite based cap. If the cap is fit in any bottle, the bottle in the water will be purified when you are taking. It is developed by some student of Jadavpur University. So inventive idea lies in many things. There is so many ideas. This company, they have developed smart water bottle. This is that smart water bottle. It is patented. This design, this Orpina trademark registered. Design of the bottle is design registered. So he has done all this. And I am giving another success story of KIT University. KIT University, this is the startup. She has started his work on 2017. She is in the microbiology area. She has done 5 patents granted, 18 trademark, 3 design registration. Afterwards, her company worth more than 1 crore. And she got National IP Award for his contribution. So these are the success story where you can work. And here you can apply for idea. In our website, you can apply for idea. You will download this form and send it to this Gmail. So here you can get the opportunity. I am not telling all these things, and there is, sorry, in many issues are associated with our Bengal Potochitro and many things. Here I am giving the course. So if you are interested, you can take it. This is 3 months, 6 months, and 1 year. And details will be dealt afterwards. And so what is role of IP in research, development? Identify your IP. We do not know we have IP, but every one of us have IP. Identify the IP, secure the IP, register your IP, protect your IP, exploit your IP. If you don't exploit, you don't get anything. So patent system added fuel to the fire of genius. It was said by President Abraham Lincoln. Only one president I know that he has patent. And before ending, I want to mention one important quote. Everywhere I mention it, Alice says, which direction should I go? Cat says, it depends a great deal on where you want to go. But Alice says, I don't know where I want to go. And Cat says, in that case, it really doesn't matter which direction you take. But you have to take some direction. Otherwise, you will be again the backbencher. So that is the message of today's lecture. Thank you. Thank you for kind patience.
Hello. Thank you so much, ma'am, for this illuminating lecture. And I think we have lots of questions. You have lots of questions in your mind, but hold it, because we have shortage of time today. We have another program just after this. So thank you once again, ma'am, for your illuminating lecture. If you have any question during presentation session, you can ask those questions to ma'am. Yes. Okay. So next, I would like to request our next speaker, Srimati Paromita Saha, Scientist B, Patent and Information Center, Government of West Bengal, to deliver her lecture. Ma'am, please.
Hello, good afternoon. Can we start now? Okay. So, this would be I think it's better to have an interactive session from this session, because you may have a lot of questions. So, as I go on, you may ask question also, okay? So, as it already been told, and you are now been introduced to intellectual property right to some extent. So, I will start with that part only, and I'll speed up my slide a little bit more. So, as we are talking about innovations and creation, because the main purpose of intellectual property right lies in the fact that if I have something smarter than others around me, I must be rewarded. And that becomes the main motivation out of it. As you all are students, you are also planning how to go about in your future lining. You should have that thing in your mind. What difference I can create in my environment? What value I can add on? The more smarter you will think of, more innovative way you will think of, the gain will obviously on your part. So, intellectual property right already been mentioned by our Dipanjan sir and Moha ma'am already, that it is basically creation of your mind. So, being a thinking creators, we have to continuously we are thinking something or other. Whenever you are confronting any kind of problem, we tend to solve it. Whether you take help of something else or you do it by yourself, those kind of creation, if it is something very novel, then we can categorize into some kind of intellectual property which belongs to me. So definitely I should have some kind of right on it. So in that concept, this intellectual property rights came into play, and these are Indian laws that guards our right on this based of intellectual properties. So quickly we will move on to the concepts, which rights are being given to which kind of ideas or which kind of creation of our mind. So basically, when we talk about invention, as already told by ma'am, not discovery, I am telling, invention, something which has been created completely through intervention or effort of my mind or problem, solving some technical problem, we called it, this can be protected under patent. So what is a patent? It is an exclusive right granted to our invention, not discovery. Only inventions are given patent, and it may be a product or it may be the process how you are creating that particular innovative product. So these are some amendments. I think this should be too much for you to know, but later on you get to know it. But what are the criteria of patent? You have to keep in mind that there are actually 3 criteria, and I'll add on some more. That is novelty, inventive step, and industrial application. So what basically the novelty do is whether your invention is something very new which is not been revealed or practiced by anybody else in the world, anywhere. So for that, we basically go in Patent Information Center, we actually give the priority search, which I will explain before I go into more about of patent. So as we are dealing with invention, definitely it deals with, because research, for any kind of research, you search, you do a literature search, don't you? So that is our usual traditional practice. But how many of you do patent search? Do you do patent search? No. So now you should do it. That is what we want to aware you of. Because these patent databases are gold mines of inventions, gold mine of various informations. So if you are not doing it, then you are actually excluding a lot of information which is not mentioned, because patent databases are hidden from the public until and unless the document is published. So you are not been able to know that some new invention is already been filed a patent, but when you are searching literature, they are not publishing, because the who are patenting, they publish it later. First they file the application. So it's better to go for a patent search. So in Patent Information Center, we give such search. So as I said, one of the criteria is novelty. So for that we give novelty search, and then we judge whether your invention is inventive or not. For that, what we do, we basically check whether your invention has technical advantage and have economic significance. Because if you invent something and it doesn't have any economic significance, then why would a person go for it? So from the prior art, your invention can be differentiated on basis of these 2 features. And by judging these 2 features, we will call that yes, this is an inventive one. So I will give you a case study on that basis. So this is one of the invention been filed in Japan Patent Office, where a small plastic container with hard carbon filling. So as the diagram shows, the plastic container has a hard carbon filling. So when the examiner got this patent document, they are trying to judge over the 2 prior art. They searched for 2 prior art which is quite similar to this invention, and they found that D1 and D2, these 2 patents are there. What D1 says? D1 says it is a small container, okay, which has, this small container, so plastic container is used as a drinking bottle, and it has a film coated outside it. And our invention says that there is hard carbon film. So their similarity is that the D1 is having silicon oxide thin film coating, whereas the claimed invention says there is hard carbon film. Both are plastic container, mind it. So what the examiner says that this is the difference between the D1 and our invention. But in D2 we found that there is another discussion that those are cups, drinking cups, which has carbon heart filling. So you see, any person who work in this kind of research work will able to combine these two, D1 and D2, and derive to this claimed invention. So the examiner says that when we combine D1 and D2, it is very easy to derive this particular invention. That's why this invention is not inventive in nature. So you have to be very careful, because what is in our practice when we do any research work, we search a lot of literatures and we try to derive something from this literature, and we derive an invention. But the problem is the examiner will also have these prior arts in front of them when they are judging your invention. So they will check whether that is your invention, ultimate product which you are claiming that is new, is it to derive from those or not. So you have to be very careful to prove your innovativeness, your inventive state in this part. That's why you can have a search before starting your research, and obviously when your research is complete and you have a wonderful invention in front of you, you can go for a prior art search. So both is quite important. So in Patent Information Science Center, this is a process which we follow for any patent search reports. We go with the keyword search, and then accordingly we use the classification method also, and we do with our expertise, we can frame a query out of it based on the databases. So these are the databases, open databases. These are free, I say. Okay, you can keep note, you can take a screenshot of this. These databases are being used by us also, but apart from that, we use a paid databases. That is the main important thing. But you can go your own, you can do your own research, patent search in these databases. Okay. So this is a classification system which WIPO gives. I think I will not go in this detail. These are the paid databases that we use, that is STN paid databases, and the databases from Clarivate. These are the paid databases. For this, you have to come to us. If you give us your invention, we can perform the search on your behalf. So as already been said to you about something has been revealed, that something is discovery, it is not patentable. So this section 3 under Patent Act talks about patents which are being patentable, which are not. So if you quickly go through it, it has 10 sections, subsections. Okay, so this subsections talks about which is not patentable. Mind it, not patentable, strictly not patentable. If your invention falls under any of this section, your invention is not patentable. As you see, something is falling under the natural law. Just we all have grown knowing some concepts based on some scientific principle. Suddenly you say that principle is totally wrong and my invention is going against that particular principle. Patent office will not allow you to file a patent on this basis, because a lot of controversy will occur and you have to definitely prove that part, that yes, your invention is a correct one, it is completely going against the natural law. So this is also brought from getting a patent. Again, if it is against some morality of having some ethical issue, like we have that some termination seeds that been generated, which can be used, those seeds can only be used for one season. Okay, that terminology technology has been borrowed from because that is also going against our ethics and morality. Next, scientific principle and natural living beings or non-living things. So scientific principle, as I said, it is coming under scientific principles would come under which? Copyright. Anything that you had, it is theoretical, isn't it? It can't be an invention. Can't call it invention. So in that case, this can be protected under copyright, not under patent. Anything related to natural living things. Natural living things, if you work on natural living things, are actually who are the owner of it? God, I would say it is not my invention. Living thing can't be my invention. Can it be? No. So anything under when you were using any living things can't be patented. Especially in case of the microbiologists, a lot of microbiologists works with microorganisms, and they say that this is an invention. Or suddenly you found some new microorganisms, and then you said then we can file a patent out of it. No, we cannot file, because microorganisms also are living organisms, isn't it? But I will come to this. There are some exceptional cases out of it. I will come to that part also. So mere discovery of a known substance. This occurs in the pharmaceutical companies and all. What happens when we use some mere discovery and all this thing? What happens? Isomers and all crystalline forms of any known substance, they have a tendency of just changing the form and file another patent on it. So, the pharmaceutical company have such a tendency, because what they want to keep their monopoly right on particular drug. Okay, so after as already been told, that we have some time limits. You cannot have this monopoly right more than 20 years. So after completion of 20 years, again, to have the market on your hold, they tend to file it another form of crystalline form of that particular active component in that manner. So that will not be allowed. When it will be allowed? Only if that has, if it is proved that that particular isomers which is there in the prior art have less efficacy than what we are now trying to protect. If they can prove the efficacy sufficiently, then it can be allowed. Mere discovery of any mixture. Suppose you are mixing A plus B and getting something C plus D, and it has been found that C plus D is completely different from A plus B, and their property and everything, their applicability is completely changing. In that case, definitely that is a patentable product. But if it is not so, if A plus B giving B plus A again, and again everything is remaining all to same, only it has been dissolved and it's giving a mixture only, then that mere mixture cannot be patented. Then agricultural methodology and horticulture methodology, any therapeutic methodology cannot be patented. Then animals, as I said, part or whole, because already said the living organisms are not allowed to be patented. But as I said, in case of the microorganisms, if you genetically create any microorganisms, that can be patented, because that microorganism has been created by you. So that's why I said that living organisms, though not be patented, but there are cases where most of you who are in field of microorganisms must have Diamond versus Chakravarti. You must have known this famous case in the microorganisms world, because this case actually changed the fate of this thing. Because previously no living organisms are allowed, but because of Dr. Chakravarti, who has challenged this part, and it has been changed that genetically engineered microorganisms can be patented in 1980. So then comes the computer programming. Computer programming per se is not patentable. No algorithms, mathematical derivation, presentations, or a method of doing business or something like that cannot be patented. These all comes under copyright. Next is traditional knowledge. As it's been said, traditional knowledge is already in the public domain. Then something which is there in the public domain can't be an invention anymore. So in that case also, it is not patentable. But ma'am already shared you that haldi has so many patents, neem has so many patents, then how can that be possible? Yes? Yes? Extraction, formulation, okay? If you are creating some herbal formulation using this neem, haldi and all these things, so definitely that formulation is being patented, not it's directly the application, way of application or something like that. Okay, so these are basically what actually traditional knowledge and everything talks about. Next, as has already been shared, that section D, I said that no new form, mere discovery of a new form is patentable until and unless you show that it has some kind of enhancement. If you can show the efficacy, if you can prove before the patent examiner that yes, my product, my form of product has more efficacy than that has been filed, then in that case, definitely it is allowed. So these are the various exemptions that we have. Apart from section 3, we have another section, that is section 4. Section 4 also talks about which is not patentable, because you know these reactive elements, you cannot deal with this like that, you cannot claim right on the reactive elements. So you have to take permission from the RDO and from the Atomic Energy, under this Atomic Energy Act, whether you can file an application or not. Definitely you cannot, under as per section 4, you cannot file application under with any reactive, if your invention is dealing with any reactive elements. So when to file a patent application? So this is my question also. Do you have this question in your mind? When should I go and file an application? Yes, student? When do you think you should file an application for a patent? After getting some result, definitely. When your product is ready, you should file an application. But should you publish and then file? Yes? Before publication. So keep it in, this is a very important tagline. File your application, seek your protection before publication, please. If you publish your application, then your application itself becomes the prior art when you are going for filing. Because the examiner will search in their database and found that it has already been published. Then something in the public domain, which is being published, can't be novel, can't be called new. So this is the time process of various stages of filing. By now, ma'am already has shown you this part. So I would say this is already a repetition of it. But as you move on with this process, if you have invention, please come to us. We will explain this part. I will not go to the interior. I only wanted to share you one thing, that if your invention is not ready, but you are somewhat sure, okay, fine, this may be an invention. What you can do? You can file a provisional application. With that provisional application, you are locking your priority. Some colleagues of yours doing the same work, and you are in a conflict that he may exceed me or something, then what you can do is you go and file a provisional application and protect it, and you do your further research, and within 1 year, you have a limit also, within 1 year you have to file the complete application. Otherwise, no use of filing this provisional application. So you have this option of filing provisional application and complete specification. So these are the fees for filing patent application. Application fees is 1,600, and other fees which are optional, the publication fees, because a patent office usually publish your application after filing your application within 18 months. But if you want, if you're in a hurry to expedite your application, your examination process, you can apply with 1,500, that is optional, for publication. Within 1 month of your payment, it will be published. And definitely, if you pay the request for examination fees also, they will examine your application, send you the FPR that I must already said, first examination report, and you have to reply it back. And if you reply it back in, and they will, if they don't have any objection with the amendment, or if they have any objection, accordingly the proceeding will follow and it will be granted or rejected. So apart from this foreign in filing, that national filing, we have international filing also. What you can do in case of this international filing, there are two ways of filing international application. One, conventional filing, another is PCT. Usually we go for PCT because PCT you get a time span of 30 months, whereas for the conventional method you get only 12 months. So you file in India, from that very day you get a time period of 12 months. Within that 12 months, you have to file to any particular foreign country of your desire, and accordingly you go for the process. But in case of PCT, what happens, just by filing one application in a WIPO, the International Bureau, you can knock the door in as many as country who are the member state of PCT. Definitely you have to mention while filing which countries you have a desire of going for the business, filing application, patent application. So with one application you can actually touch a lot of countries. So this PCT definitely is an advantage, has more advantages. So in case of PCT, and these are the fees that you have to follow in. When you will go for it in details, we will go. I will just skip this part. So apart from this, so in case of patent, any question? You have a bold idea over it now? Yes? So I'll move on to the next part, design. So ma'am already has shared you what design is. Could you find anything coming under this kind of protection in this room? Yes? No question? Metal? Yes. No, as you can see, what is been highlighted here, which property is protected under design? Yes? Yes? I want to answer from you people. Student? Appearance. So, any lucrative thing that you can see here? I can consider this lampens. Isn't it beautiful? Yes? If I keep a simple lamp and this lamp side by side, which one you should go for? This one? Right? Why? Because of its look. Just because of its look. Because both will lit light. The purpose being served by both as the same. But I will go and buy this one because I like this one. Isn't it? That is the value this has been created here. And that is serving the purpose of increasing the value of that simple lamp. Its look. So the appearance is being protected here. If you have two same kind of bottle, but one bottle which looks good will be more attractive for the customer and he will buy that bottle. So in that case, this design is protecting that part. So design registration is given to that, just the outer look, the aesthetic value that's been added to that product. If you look at this chair is made up of biodegradable plastics. I said just plastic, sorry, not biodegradable, just a plastic. So when the plastic that we throw away, with that they have designed this chair. And you see the design is very unique one. Very different from the usual chair. it serves the purpose of recycling the plastic. That's the different aspect. That's a different aspect. But the most important, the look of the chair is very different and it's a unique one. And definitely this design is been registered as a design registration, not the any other thing, not the manufacturing process or something like that. It's not important here. How you create this product is not important. What is important is basically the design of the chair, the design of this lamp is important. So, any material, anything that been manufactured two-dimensionally or three-dimensionally can be registered under this Design Act if it is having some unique design. And the process, means of manufacturing is not important here. The term of protection is basically 10 years. It can be extended up to 5 years at most, so 15 years in total. What cannot be registered under Design Act is that, like certificates, map, any emblem. So trademark, because it's a different domain of IPR. Cartoons, labels, this comes under copyright. They cannot be registered under design. This is a case based on design. Here somebody, as I said about this lamp, the simple lamp and an artistic lamp. Similarly, here also, Gopal Glass Work Limited, they have filed a designed application over this diamond-shaped glass sheet. Okay, whereas this Bharat Glass already has working with this diamond glass shaped glass sheet, but this diamond shaped design is being used over some roller aspect. It's some iron roller aspect, and the look of the design over how Bharat is using and the look of the design how the Gopal is using is completely different. So the design controller, when design controller have seen that both the same design been used on different material. That is the only difference. Design is same, but since the look is different, the Gopal glass work have been they were allowed to file this design application. That's why I said the look is important here. The aesthetic look is important here. Now, it's not that whether you're the same, if it is whether it's the same pattern or not, but ultimate look of the whole product, if it is different from what it is there in the prior art, definitely it will be called as a new design. So this is the site of WIPO. You can keep a note of this also. If you have some design and you want to check whether it's novel or not, you can use this link to search for the design. Fees for filing a designed application, just 1,000. Next quality of the product that we will talk about, trademark. Already been told to you. What trademark basically talks about? Yes? Trademark talks about? Students, are you listening? Yes? What is trademark? Yes? Why there are various kind of computers being used by you. Which laptop do you people use? Most of you? Why? Do you know who is HP? Do you know? Why do you use HP? Why not Dell? Why not House? There are many other companies, isn't it? But you like HP. Why? Yes? No, that is not the thing. You don't use it because of their brand value. Because it is cheaper, just because it is cheaper. So its performance doesn't matter to you? Yes? Its performance is also important. Because if it is not good, you wouldn't have bought that particular product. So, by using an HP, somebody around your environment have told you that this computer, this laptop, these products are good. So anything under HP is good. That is a goodwill that they have earned. Okay? With time, that goodwill is actually their asset. That has increased their brand value. And that is what is been protected through that particular trademark HP. So, that is what trademark is all about. Similarly, in case of this GI also, this is also a trademark, but this is not owned by a single person. It is not a monopoly right of a single person. It is a monopoly right of a community. So that is the only difference between trademark and GI. Both are protecting the quality of the product and the recognition of the product. So these are some well-known names, and already been said by ma'am that when you are intend to file a trademark, you should have two basic requirements being fulfilled. One, it should be distinctive. Another, it should not be deceptive. Ma'am already said you cannot file a descriptive one, because when you are filing something descriptive, that kind of trademark is not distinctive. To have a distinctive trademark, it should be something just by look you cannot think. Because HP, if you just say HP, can anybody say that that's a computer or something, that's electronic goods or something like that? Yes? Can anybody thought of that? No. That is the why, that is the fact, this is very distinctive. This is a very strong trademark. You cannot derive from, but suppose you use Apple logo for some apple grower. So it can be easily, that's an obvious thing, okay, it's an Apple farm, so they are using Apple logo. So that it is not that distinct trademark. Okay? So, and regarding the deceptive part is also very crucial. As already shared by ma'am, the real leather. Suppose you are using a trademark called real leather where L is 1. You are not using double. So no dictionary has this kind of letter, and that's why this is a unique one. Okay, fine. You go to the trademark office, you file your trademark, but examiner will keep a question mark, send you an objection. Why? Because real leather is actually talking something about your product. People will think that you are trading some real means original genuine leather. But if the examiner finds that actually your good is not artificial leather and you are giving a tagline of real leather, so what you are actually fooling the customer, isn't it? So you are creating confusion in the customers. So that is why it should be, it is something deceptive. So you cannot say that. So you will have an objection in this part. Certificate marks, this is also one kind of trademarks. This will be given to those people who actually fulfill the standard of that particular certificate mark. So you have to fulfill certain standards like ISI and FPO, so to use that. Then collective marks is being used by some organizations where only the member of that organization are allowed to use that kind of collective mark. R and TM is already known to you. It's no use telling it now, but the term of protection, same as GI also. That is, when you file the application, you get 10 years. After 10 years, you have to renew as much as long you want to keep your trademark, you can renew and you can keep your right. So, trademark also has some certain areas you can go to the trademark office for your and apply for application for the search. You can come to us. We also give you trademark search, and otherwise you can in WIPO also there are portals. They have databases where you can search before filing the trademark. This is the application fees for trademark, because as I said, for design and trademark all has their classification thing. For each class you have to pay an application fees. Okay, so sometimes it happens you have many products, so different class of products. In that case you have to file payment, you have to pay according to each class. Even if you are filing one application, you have to pay different fees for each class. 4,500 for each class size. This is geographical indication already shared by ma'am. That is, it's a grandfather's invention, but it is similar to trademark, but it's related to something, to a community who belongs to a common geographical area. Okay, if its origin is to certain geographical area and it has been used and been popular in a particular origin or particular geographical area, those kind of products are basically protected under this brand names. So we have then trademarks. Trade secret is also a kind of IPR. Most of you must have curious to know what formulation basically this Coca-Cola drinks are using. Nobody knows. Anybody knows the formulation of Coca-Cola drink? No. This is been keeping as between them only, two or one or person maybe knowing that, and they have some non-disclosure agreement between them, and they were not allowed to reveal to any third party, and that's how they have protected. Till date, they have been protecting this trade as a trade secret. So this is also a way of keeping your protecting your IPR. Next, last but not the least, is copyrights. Already been told to you, any artistic literary work you can go for copyright. So first of all, most important thing, today in the morning also we were having a talk about this copyright. Copyright is a automatic right. The moment you are creating or writing something, but I would say you are converting your intangible thing into tangible form, then only it becomes something that can be stolen or taken away from you. Because until if it is in your brain, then nobody will steal it, isn't it? So no protection is required. So the moment this intangible form is converted or attached to a tangible form, then your protection is required, and then only the protection things and rights and all those things comes into play. So as a bundle of right, you have author right with it and some related rights. So what are these related rights? The related rights are basically this bundle of rights. These are also called economic right, because with this right the fund is been generated. The investment you have done, you get the return out of it. So these are called economic right, because if you are writing something in your diary and putting it in your cupboard, then there is no bundle of rights. There is only one right, that is author right. But the moment that story or the poem is being converted into some kind of a play or some kind of cinema or something like that, theater, so in that case what happened, a lot of people are involved in this process and each have their own intellectual part. They are adding something, somebody is adding music to that particular song, or to make it that, and then broadcasting it to the people. So all these people have their own rights in it. So that at that time this author right is being divided to various related rights. So apart from this author right, economic right, related right, what we have, which is, I would say, most stable right, can't be transferred, non-transferable right, non-transferable right. This is actually the moral right. So what is this basically moral right is all about? Anybody has any idea? The moral right remains with the author. even the author may give, sell their copyright. Many author give their authorship right to somebody else. That can be transferred, but the moral right cannot be transferred. It remains with the creator only. Okay, so in this, this is a famous case where Mr. Saigal, a very good artist, he sculptured a statue and have given to the government of India. It has been situated in the Bigyan Bhavan in Delhi, and during some kind of innovation work, what happened? They have to remove the statue and have been placed to some place where the statue was not in a good condition. The moment Mr. Saigal found that, he filed a suit against it. And actually government of India has to pay him back. He has to pay the compensation, the moral right, under the moral right. Because when the sculptor has given his design or this sculpture to the government of India, the copyright belongs to the government of India. Okay, but the moral right remains with him. So you cannot disregard his work, you cannot misuse his work. That affects his moral right. So exceptional things are also there, because while doing this presentation, I am, or everybody must have taken things from internet. We have also taken things. It is not possible for us always to seek permission from the people, isn't it? So are we not violating the copyright? Yes? Are we? Are we infringing? Yes? No. Because we are not using it for our benefits. We are not commercialized. We are not selling this copy, more than 50 copies. The moment you are producing and selling it more than 50 copies, the Copyright Violation Act comes into play. Okay, this is a fair use, because I am doing it to teach somebody, to aware somebody of this fact. I'm not earning anything out of it. The moment I will go and sell this copy more than 50 copies. I can produce only up to 50 copies, not more than that. If I do so more than that, in that case, definitely I am actually violating. Otherwise, I can call it as a fair use. Okay? And not infringement. And another thing I would say about copyright, please keep it in mind. Many a time it happens, suppose you are in some kind of project, okay, maybe you have got the project from that and you are working on that. In many cases, in the R&D also we do, some projects comes and the fund been given to us, and under that project we work. Who will be having the copyright? Who will be the owner of that IPR? Some IPR. That has to be clear in proper agreement. In absence of any agreement, the funding person becomes the owner. Okay, whoever is investing on that particular product will become the owner. But if there is some kind of agreement with regarding the ownership, then that is different. So this is the filing fees of copyright as others. If you have simple thing that you have to file, 500 minimum fees. So it's also an online method. You can do it by yourself or you can take help of ours also. Thank you. So that we have for today. If you have any question in this regard, you can go about it.
Thank you so much, ma'am, for your illuminating lecture. Now we are going to our last portion of this technical session, that is vote of thanks, which will be offered by our Barsa sir and Dr. Upendranath Nondi. I'd just like to request Dr. Nondi to offer vote of thanks to the audience. And after that, we will go for presentation of your innovative ideas through posters and presentations.
Thank you. So, I would like to thank all the audience for giving me this opportunity.
Okay, it will be a parallel session. Those who want to express their ideas through PowerPoint presentations, keep it here. And those who have posters, they go to outside, just in front of Millennium Building gate, where students will go, and also our resource persons will also go to see your posters. Thank you. Sir, please.
হ্যালো ওহ এতক্ষণ ধরে আমরা যে সমস্ত সুন্দর বক্তৃতা শুনলাম তার একটা কথাই বাংলাতে বলা যায়, যেখানে দেখিবে ছাই উড়াইয়া দেখো তাই, পাইলেও পাইতে পারো অমূল্য রতন। সুতরাং সব ক্ষেত্রে কিছু না কিছু আছে, আমাদের খুঁজে দেখতে হবে। সেই বার্তাটা আমার মনে হয় আমাদের কাছে পৌঁছালো। So we are at the event of giving vote of thanks. A very good afternoon to you all present in the grand event of inauguration of IPR Cell and interdepartmental presentations on innovative ideas for IPR. On behalf of the organizing committee, I am glad to be standing here to express my vote of thanks. A special thanks to our chief guest, Dipanjan Bhattacharya, Special Secretary, Government of West Bengal, and Administrative Officer, West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal, for accepting our invitation and for being here with us today. Sir, your thoughts have truly inspired us. A particular mention goes to our esteemed principal ma'am, Dr. Madhubanjari Mandal, who inspires us to achieve our best and serves as a pillar of strength. I would also like to thank Dr. Supratim Das, Vice Principal of our college. We express our heartiest congratulations to the speakers today, Dr. Mohua Hom Chaudhary, Scientist C, Patent Information Center, West Bengal State Council of Science and Technology, Department of Science and Technology, Government of West Bengal, and Srimati Paramita Saha, Scientist B, Patent Information Center, West Bengal State Council of Science and Technology, DSTBT, Government of West Bengal, who spoke beautifully on the subject. I also like to thank Dr. Samrat Bhattacharya, IQAC Coordinator, Joint Director of R&D Cell, President, Institution Innovation Cell, Dr. Bidisha Sinha, Senator Secretary, Sri Vivas Vacharjo, Vice President, IIC, Nodal Officer, IPR Cell, Dr. Partho Haldar, Dr. Niranjan Chakraborty for comparing the program in a flawless manner. Special thanks to Dr. Ishita Shur for working silently but effectively at the background. Heartiest congratulations to heads of the department, members of various committee, the students, the NTS staffs, and all the present colleagues from other departments. Thank you all.